In Penal Code Section 459, California law defines auto burglary as entering a locked vehicle for the purpose of either stealing the vehicle itself or stealing contents from inside the vehicle or committing some sort of felony while inside. If you actually steal the vehicle itself, you're more likely to be charged with grand theft auto, which is a more serious offense. But if your purpose is to steal a radio or a backpack or something inside the vehicle as opposed to the car itself or the truck itself, then you're more likely to be charged with auto burglary.
In California, in residential burglary, there's no requirement of forced entry. By contrast, in auto burglary, by definition, the car must be locked. For example, if you see an unlocked car and you enter that unlocked car and steal a stereo, that might be theft, but that is not auto burglary because the car was not locked.
Auto burglary in California includes stealing something from a locked trunk of a vehicle. So if you bust open someone's trunk with the intent to steal something from inside that trunk, you would still be liable for auto burglary even though you never actually entered in the cabin of the vehicle. And this encompasses situations where you didn't even actually take anything. Say you bust open someone's trunk with the intent to take something from inside that trunk. Now, once you open the trunk, you find out there's nothing inside and you decide to walk away. You would still be liable for auto burglary because you entered that locked trunk with the intent to steal something from it.
So you could be liable for auto burglary even if you didn't complete the theft that you intended. For example, let's say that I pick a lock on a car and I reach inside with the intent of stealing a stereo. But once I reach inside, I change my mind. Maybe it's too risky. Maybe someone's watching. Maybe I feel that it's morally wrong. So I don't steal the contents. I just walk away. Even in that situation, I could still be liable for auto burglary because I entered the vehicle with the intent of committing a theft.
In California, auto burglary is considered a wobbler offense. That means that the prosecutor can charge you with either a felony or a misdemeanor. If you are convicted of auto burglary as a felony, you are facing up to a maximum of 3 years in state prison. If you are convicted of auto burglary as a misdemeanor, you're facing up to 1 year in the county jail. But the worst part of being convicted is that you have a conviction to a very serious offense, which will make it difficult to obtain future employment and other benefits. So if you're charged with auto burglary, you need to do everything you can now to fight this case and keep it off your record.
This is the kind of offense where we see a lot of people get wrongly arrested and sometimes wrongly convicted. The good news is that here at the Schaus Law Group, we have a strong track record of getting auto burglary charges reduced or even dismissed.
One common defense to an auto burglary charge is that the vehicle was unlocked. Or to look at it another way, the prosecutor has to prove beyond a reasonable doubt in court that the vehicle was locked when the burglar entered. Now, the prosecutor will attempt to prove that by either showing that there was forced entry or else calling the owner of the vehicle, the victim, to testify that they had left the car locked and secured. But a lot of times it's not entirely clear, and when there's doubt as to whether it was locked to begin with, the person is entitled to an acquittal.
Another common defense of auto burglary is misidentification. Misidentification is the #1 reason that people are wrongly convicted across the United States. There may have been an auto burglary in the vicinity. A witness may have given a description of the person they believe to be the perpetrator. The police may have taken that description and decided that you fit it, even though you are innocent of committing that crime. It's our job as criminal defense attorneys to demonstrate to the prosecutor, to the judge, and even a jury, if it goes to trial, that this is a case of mistaken identification and you were not the perpetrator.
Another common defense to an auto burglary charge is by asserting that you were just merely present at the time the crime was committed. Now, for example, say you're hanging out in a parking lot with one of your buddies, and your buddy says, "I'm going to break into that car and take the iPad out of the back seat." Now, you're not in on it. It wasn't your idea. You just happened to be there at the time. Thus, you would not be liable for an auto burglary. And here at the Schaus Law Group, we have a strong track record of getting these kind of charges reduced or even dismissed.